Inheritance Law Part 2 and join me as I travel through Quezon Province! And welcome back to the channel. This is the House of Law. Thank you for watching my videos and for subscribing to this channel. If you're new to this channel, you know what to do. Please subscribe and click that notification bell so that you will be notified in case I upload a new video. This is part 2 of the Inheritance Law series, Succession by Operation of Law. In the first video, I talked about inheritance or succession by a will, whereby a person executes a will while living, and upon his death, his estate will be distributed according to his wishes as stated in the will. Pero the more common situation is that many of us die without a will. So paano ngayon hahatiin ang ating estate kung wala tayong will? So in the civil code, we have this type of succession called succession by operation of law, also called intestate succession. Now, according to the civil code, there are compulsory heirs, and these compulsory heirs are the spouse, the children, whether legitimate or illegitimate, and then there are the secondary compulsory heirs consisting of the parents and the brothers and sisters. But the rule is that intestate succession prefers the down line first before the ascending line, and then finally before the collateral line. So ang priority talaga sa division of the estate is that yung mga anak. So kapag may mga anak, walang mamanahin ang mga magulang. At ganun din, kung halimbawa may mga magulang, wala ring mamanahin yung mga kapatid. So that's the rule of preference in intestate succession. Now, the main feature of intestate succession is the legitime. And this legitime is an imaginary computation of the shares of each of these compulsory heirs from the estate of the deceased. So, remember I said in the earlier video that usually it's 50% of the total estate. Now, the other 50% being the free portion. So let's first compute the 50% which is reserved for the legitime. So out of this legitime, each of the compulsory heirs will get one share each or one unit. Now, the illegitimate child will get 1/2 of what a legitimate child will receive. This imaginary formulation will of course come to being once there is a settlement, because in the settlement of the estate, uunahin muna i-check kung may ari-arian ba yung namatay, pangalawa kung may mga utang ba siya kasi dapat bayaran muna yung mga utang, at saka pagkatapos doon ay alamin kung sino-sino yung mga heirs at kung buhay pa ba sila, dahil kung patay na sila, then they can be represented by their respective heirs. So basically it's a long process, but the procedure is provided for by law. Now, there are two types of settlement. You have extrajudicial settlement and the judicial settlement. Judicial settlement being done through the courts, and extrajudicial settlement done by agreement of the heirs who are present at the time. But there are more to intestate succession other than, of course, executing these documents. So we will learn more about that once we take our lunch. Let's go. Behind me is the Heirs Summit here in Quezon Province. So let's continue. As I was saying, there are two ways by which the heirs can divide the estate of a deceased person. First is by extrajudicial settlement, and the other is by judicial settlement. Let's first start with extrajudicial settlement. An extrajudicial settlement is proper when the deceased person did not leave any will, and if he did not have any debts. Well, of course, it presupposes also that the heirs have agreed amicably to just divide the estate and adjudicate the properties among themselves. So how do you go about with an extrajudicial settlement? Well, first, I would recommend that you get a lawyer to prepare for you the extrajudicial settlement document. It's a legal document, it's a public instrument because it's notarized, and here in this document, the names and addresses of the heirs are listed, and also the properties of the deceased person are inventoried. Now, they will have to agree kung kanino mapupunta yung mga properties, or if there are arrangements when to sell the property to a particular person, then they can also include that deed of sale within the extrajudicial settlement. Now, this extrajudicial settlement must be published in a newspaper of general circulation at least once a month. Okay, and next, it must be registered with the register of deeds of the place where the property is located. Okay, so that's extrajudicial settlement. Oh, by the way, before I forget, this extrajudicial settlement can be challenged within 2 years from its registration. If, let's say, there's an heir who was omitted or who was not included in the agreement, or if there are creditors who were not paid from the estate. Okay, so the second type of settlement is, of course, the judicial settlement. Here, the heirs will petition the court to help them settle the estate. Well, basically, they go to court to ask the court to appoint an administrator. And this administrator is either an heir or any interested person or any person whom the heirs trust, like a lawyer. So the administrator's duty, once appointed, is to inventory or to make an inventory of the properties of the deceased person, check if there are debts so that these debts can be paid off, and after getting the net estate, then submit a plan to the court for the distribution of the estate to the rightful heirs. And once the court approves that, then this order will now be registered with the Register of Deeds where the properties are located, and that will be an authority for the Register of Deeds to issue new titles to the rightful heirs. So there, whether it's extrajudicial settlement or judicial settlement, it really depends upon the heirs and upon the circumstances. So that's it for the part 2 of the inheritance law. I hope you learned something valuable today. Thank you very much for watching. If you enjoyed this video, please drop a like, and please don't forget to subscribe and click that notification bell so that I will see you the next time. Sa lagi tatandaan, isip ay buksan, alamin ang batas.